Hello and welcome to today's Community Legal Centres Queensland webinar. My name's Carly Hanson and I'm one of the Sector Sustainability Coordinators here at Community Legal Centres Queensland. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's session. In Meanjin or Brisbane, where the CLCQ office and QAI office is based, they are the Turrbal and the Yagara people. I wish to pay my respect to their elders, past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people throughout Queensland and across the country, I'd also like to pay respect to the traditional owners throughout Australia and extend a very warm welcome to any First Nations people who are listening in today. So I'm really pleased to welcome Sian Thomas, one of the principal solicitors at QAI in the NDIS advocacy practice, to present today's session, which is supporting clients to appeal a decision by the NDIA. Just a quick overview. So many CLCs in Queensland will have potentially experienced an increase in inquiries recently relating to appeals of decisions of the National Disability Insurance Agency, the NDIA. Those those decisions of appeals generally fall into two categories: a refusal to grant access to the NDIS or a refusal to fund requested supports in a person's plan. These decisions can have significant impacts on people living with disability, and the reasoning behind its decisions is not always transparent. So today in this session, Sian will provide a bit of an overview of the key criteria the NDIS must apply when making decisions regarding access and supports, the internal and external appeal processes and timeframes for an appeal, what happens in the AAT and the reports and statements which can support an appeal, and QAI's insights on how community legal centres can support clients going through such an appeal process. So I'll hand over to Sian in a moment to tell you a bit more about herself, but first just a bit of quick housekeeping. So today's webinar is being recorded and we'll have the recording available to download later today or tomorrow. The PowerPoints have been emailed out to everyone who registered as of about midday today, but if you weren't able to grab those, you can download those from the handout section of the GoToWebinar control panel now. We do encourage you to ask questions, of course, and you can type your question into the question box on the GoToWebinar control panel and we'll read those questions out for you. We will hold questions until the end of the session, but feel free to type them in as you think of them. So I might now hand over to Sian and I'll speak to you again at the end of the session. Thanks so much, Sian.
Thanks, Carly, for that introduction. And thank you everybody for attending today. I am just going to put my my video on just very briefly so that you can all put a face to the name. And as Carly said, I'm the principal solicitor job share with Andrea De Schmidt at QAI in Brisbane. And we, between us, run the NDIS appeals practice here. So now that I have shown my face to you all, I will hide away for a moment. It's just all warming up, won't be a moment. And so, yes, I too would like to begin today by acknowledging the traditional custodians on the land which I'm on today, which is the Jagera and Turrbal people, and pay my respects to their elders past and present. I extend that respect to all traditional custodians of the lands which our attendees are on, and I saw earlier today that we have people from all over Australia, and any Aboriginal and Torres Strait Islanders, welcome people here today. We acknowledge the stories, the traditions and living cultures of Aboriginal and Torres Strait Islander peoples on this land and commit to building a brighter future together. So just really very briefly before I start, QAI, also known as Queensland Advocacy Incorporated, is based in Brisbane. We're an independent, not-for-profit advocacy organisation with specialist community legal and a specialist community legal centre. We've got a number of services. All our services are to support people living with a disability, and we were working in the NDIA space is really important and a big area for us. So we're certainly taking a lot of learnings from our casework to support our systems work here at QAI. So just an overview for today. And look, if there are people here in the audience who are practicing NDIS appeals all the time, this might be a little bit simplistic. I have sort of taken it back to first principles really, and want to cover the whole range of appeals that occur. So we'll just look really briefly at the NDIS and plans and what they actually look like. Then I want to cover again briefly and not in a lot of detail the criteria that go into the decisions around access to the NDIS, and also to what supports can be funded in a plan. We'll cover the process to ask for the review of a decision, our tips for applying for an internal decision, and also our experience and our tips in the tribunal itself. So I'm sure everyone's aware the scheme and the agency, the National Disability Insurance Agency, which is responsible for the scheme, was established under the legislation in 2013. The NDIS Act, amongst other things, sets out the criteria for access to the scheme for a person, and also the criteria for funding supports for a person. Some interesting sort of stats that I looked up in advance of this, but we've also been experiencing recently. You know, there are now over 500,000 participants in the scheme. I think when they originally did the Productivity Commission report, they were anticipating around 400,000 participants. So the numbers in the scheme are growing. I think last year there were about 87,000. Repeat that. The participant numbers are increasing. If you are working in the area of NDIS, you will know that there has been recently, in the last certainly 12 months, an approach by the NDIA around trying to limit their spending. The estimated cost for this financial year is $29.2 billion, and the projections that I took out of the report today are that by 2025 it'll be moving to 41 billion. Now this is a really interesting statistic, but it is also something that we at QAI are experiencing on a daily basis, and that is over the last 12 months, from December 2020 to December 2021, the number of cases in the AAT has effectively quadrupled. So just over 12 months ago, there were 405 cases involving the NDIA in the tribunal, and at December there were 1,910 cases in the tribunal. So just an exponential increase in people appealing decisions of the NDIA over this last 12-month period. From our perspective, I think we certainly started to experience that increased demand around the middle of last year. And there are various reasons for that, which I won't go into, but I know that it's putting a lot of pressure on the advocacy agencies, groups that are funded for NDIS appeals, and in part that's why we're doing this seminar, because we need all the help we can get. All right. So, and I do apologise. This part might be a little bit repetitive for some, but I thought it would be useful just to recap on what a plan is. So once a person is a participant in the scheme, they will have a planning meeting, and their goals will be discussed, and a plan will be produced by the NDIA after that meeting, which sets out what their goals are. The plans are time limited, so most often we see them being for 1 year. We are seeing more often now the plans being for a period of 2 years or even 3 years. One observation we've made recently is that where we think the idea of a sort of a time limited plan is so that they can be reviewed regularly to meet a person's needs. Where we are seeing these longer plans, sometimes that might suit the participant, but it also has been some concern for us, particularly for new participants in the scheme. So that's something to watch for. The supports are then listed in the plan. I have actually put a redacted plan together just very quickly. I'm going to move this to my screen so we can see what a plan looks like. The total funded supports are listed up the top and the period of the plan. And then the plan, the funded supports are usually split into really two main categories, and that's your core support and capacity building, which is the therapy type supports. What we find, and certainly when I first started this work, you look at this plan and you see, okay, well, someone's got some core supports here and there's a figure, but there's very little else to tell you or the participant what is actually sitting behind that number. So I certainly found that challenging in the early days when I started doing this work, and then you can see the capacity building supports there in the plan. I'll move that off. As well as the sort of key supports around core support, which is really support worker time, capacity building, which is therapy support, so speech pathology, and the like. The plans can also include funding for a support coordinator and or plan management. They can include funding for home modifications or assistive technology, and also specialised disability accommodation. Now, I'm not going to talk about any of those in detail, but those are some of the things you can see in a plan. We find sort of interpreting what is sitting in a plan. The NDIS price guide can help. So there's some rough figures in there, and with a calculator you can do some backtracking to kind of guesstimate perhaps how many therapy hours have been budgeted into the plan if the participant doesn't know. And also if a person has a support coordinator or the local area manager, they can also help to work out what is funded in a plan. And I probably would add that sometimes we have seen that plans get appealed, certainly at the internal review level, where they might have been appealed in part because there isn't it's not transparent as to what has been funded. So it might have been there, but there's a sort of disconnect between what was funded and what people thought they had. Okay, so as flagged at the beginning of the session, The most common reviewable decisions are access, which is where a person is applying to become a participant in the scheme, or the supports decision. Now, we recently attended a seminar with the AAT, and their feedback is that at present, around 85% of the decision of the matters that they have in the AAT are about supports, and around 11% are around access. The remaining, you know, will go to other things like management of a plan, or, and I think increasingly compensation, which is a whole sort of new area, another area of the NDIS Act, which I think will become a big new area, but we're yet to see that come through the clients in big numbers yet. So I don't want to go into a lot of detail about the access requirements, but I think it does help to have a look at what these criteria are if you have a client who is looking for access to the scheme. They're set out in Chapter 3, Part 1 of the Act, and you have to meet the criteria to get into the scheme. The key criteria is the age requirement. So you have to be under 65 at the time you make the request. And so this may have a ramification for somebody who has applied perhaps when they're 64. The decision comes back to say that they haven't met the criteria. Their only option, if they have then turned 65, is to appeal that original decision, because they cannot make another access request because they've now turned 65. The residence requirements, so generally it's Australian citizens or those holding a permanent visa. We do see, and you may see in your practices, if you're a New Zealand resident living in Australia, in most circumstances, you will not be eligible for the NDIA depending on your visa status and the time you move to Australia. So that's one to watch. There's a few complications on that if you are getting New Zealand residents, and particularly if you're getting children of New Zealand residents coming in. So there's more to unpack in that one, but we're not seeing it commonly. And then the disability requirements or the early intervention requirements. And for the purposes of today, I'm just going to look at the disability requirements in Section 24. The early intervention requirements in Section 25 are most often used for children under 6. So the disability requirements, if you've got someone who's looking to get access to the scheme, Section 24 is critical to review, but also the rules, the NDIS becoming a participant rules, and and I think probably less important, but it's still good to see because you can see some of the practical things the NDIA look for is the Access NDIS operational guideline, and there's links to those documents in the PowerPoint. Now, a person will meet the criteria, the disability requirement criteria, if the person has a disability that is attributable to one or more impairments. This one, it's only one impairment you need to gain access to the scheme. So if a person has a physical impairment and a psychosocial impairment, depending on how the other criteria flow for that person, it may be that they will just apply for one of those impairments, and that would be the primary impairment. Secondly, that impairment, the impairment that you're seeking access for, has to be, or likely to be, permanent. The impairment needs to to result in a substantially reduced functional capacity to undertake activities of daily life, and the impairment affects the person's capacity for social or economic participation, and the person is likely to require support under the scheme for the person's lifetime. Now, probably the criteria that we see, I wouldn't say most often, but is definitely particularly challenging for many applicants, is the permanence requirement. It's not enough for your GP to say that your impairment is permanent. There needs to be medical evidence put to the NDIA that the impairment is or is likely to be permanent, and only if there are no known, available and appropriate evidence-based clinical, medical or other treatments that would be likely to remedy the impairment. This one can be particularly tricky, and it does require the person's treating GP or other specialist to address in their report on application all the treatments that that person may have explored, how those treatments, what was the outcome of those treatments, and that there'd be no other treatment that could remedy the impairment. Where we see sometimes on the evidence people get unstuck is if a specialist would say, physiotherapy is likely to assist, full stop. If the physiotherapy is not likely to remedy the impairment, but is something that just is helpful in that person's daily life to manage the impairment, that needs to be really clearly articulated by the GP or the medical specialist. And we do see those throwaway comments like physio or hydro might be helpful, coming back and meaning that at first instance access is not achieved. I have given that there is a case example here, McFarlane, which is worth having a look at, but it can see how tricky things can be for applicants. For Mr. McFarlane, he suffered from chronic pain and a back injury. I think this is the right case. I'm having a mental blank on this one, but he had an opportunity to join a pain clinic and hadn't fully explored that treatment, and the tribunal said no, until he had fully explored a pain specialist clinic, they couldn't say that his impairment was permanent. The second big one on access is functional capacity, and really the best evidence that a client can have is a comprehensive functional capacity report done by an occupational therapist. This is challenging for many of our clients because there's there's a cost, and there's also it's difficult to get occupational therapists these days because in part because of this scheme. So the cost of getting an OT report is in our view, is a barrier to access. If an occupational therapist report is not available, then, and often it's not, we encourage people to get, a good report from their GP, a good statement from the person or their carer, which addresses the key criteria of daily life, being communication, social interaction, learning, mobility, self-care and self-management. Self-management. Now, in meeting this criteria about functional capacity, you do only need to satisfy one of those 6 activities of daily life. So we encourage people when they are doing their access application to really focus on those activities that are most impacted by their impairment. And we say, you know, no detail is too small, and to be really specific, rather than say, you know, I find opening the fridge door difficult. If you can't open the fridge door, you say, without help of another person, I cannot open the fridge door and I need somebody to open it for me. It's really, the more detail on your functional ability, the better, on everything that happens in your life. There is a federal court decision that looks at the functional capacity requirements. I'm not going to go into it here, but the link is there if you want more information on that. Okay, so now on support. So this is where somebody already has access to the scheme, and they're looking at what supports can be funded in their plan. And I think I mentioned earlier, generally a plan is made on access or at the end of a plan period, or there is an ability to ask for a change of circumstances during a plan period if something changes for a person. And that's a whole other topic, but I won't go into that just at the minute. The process for making the plan, just like getting access, is you do need medical or allied health reports to be submitted on a plan review. So again, we're finding we're getting people on their first plan getting a little bit unstuck at this stage, because all of the reports that have been submitted for that person were really targeted at meeting the access criteria and not the criteria for supports. So again, something to think about if you're supporting someone through an access criteria, that the documentation that you're getting together for that person will also help inform the supports that can be funded in their plan. The key requirements for funding supports are set out in section 34, and they're commonly called the reasonable and necessary criteria. You also need to have reference to the rules and the operational guidelines. Just talk briefly to the reasonable and necessary criteria, because that term is bandied around a lot, but it's not in and of itself defined in the NDIS Act. To fund a support, the NDIA must be satisfied that the support meets all of the criteria in section 34. And so those key criteria are that the support will assist the person to pursue their goals, objectives and aspirations, that they'll assist a person with their social and economic participation. And this one is a biggie that we're seeing coming up both at the internal review stage and, well, these next two, and at the AAT, is that the support represents value for money. And there's a little bit more to that, and it represents value for money in that the costs of the support are reasonable relative to both the benefits achieved and the cost of alternative support. So we don't see that as being a criteria that the agency can say, we're not going to fund that support because it's not sustainable for the scheme, although that is something they are trying. It must be reasonable relative to the benefits to the person. So sometimes this one's a clear cut. If there's two supports that could be provided that do similar or same things, then the one, unless there is a particular reason that goes to safety or something else, then the lower cost support should be funded. but we're seeing this applied to almost any support that is being sought by a participant that falls outside of a sort of set kind of criteria. So if you need 25 hours of support worker time a week, the response will invariably be it's not value for money. Now the fourth one again is one we see coming up a lot in appeals, and the support has to be effective and beneficial, having regard to current good practice. So this is where it's important that a person's treating allied health professionals particularly, they really need to be being very clear about what it is that the therapy is trying to achieve and how it's related to that person's disability as well. We do see E a lot as well, which is, you know, they need to take into account what's reasonable for a person's family and carers to provide for a person. And where this one, we see this come up quite often, is where a person's in a life transition. So, you know, when children are turning 12, 13, there can be a change in what would be expected from a parent to do for a child. And again, as school finishes and so on and so forth. So with this one, it's important to show that what a parent or a carer is being required to do is well over and above what would ordinarily be expected. And it does factors like the age of the participant is important. And finally, the last one is the NDIA won't fund a support that is provided through some other government organisations. So, for example, doctors, medicines, education that's provided through the public education system or the public health service, they all get picked up in this last criteria. All right, probably spent too much time on all of that. So let's start talking about appeals themselves. How am I going for time? Oops. Sorry, I've lost my slideshow. And okay, so a person comes to you and they have a decision which they're not happy about. Those decisions that we're particularly focused on are the plan or an access not met criteria. The decisions that can be appealed on a merits review are listed in section 99 of the NDIS Act. There are about 33 decisions in that list, and the two most common that we see are 1 and 4, does not meet the criteria, or a decision to approve the statement of participant supports. An appeal or a review of these decisions is a merits review. So the reviewer can look at the whole, you know, a fresh look at the facts, the evidence. New evidence can be submitted. So they're not having to put themselves at a point of time, so to speak, when the original reviewer made the decision. They do get to sort of look at new evidence. Unfortunately, we have seen internal review decisions through QAI where the reviewer has refused to look at new evidence and taken an incorrect approach to an internal review. But nonetheless, it is merits review. One of the things we notice is that often the process, so a process for a participant has not been ideal for lots of reasons, time, you know, things might have been late in responding. The appeal process through this is not the place to sort of revisit a process error. It's really about, especially when you're in the tribunal, it's really about what was the correct and preferable decision. The tribunal is not particularly interested in the fact that perhaps the NDIA took 5 extra days to give you a decision or the process. So it is a fresh look at what is being sought, and it's a fresh look at the decision in the tribunal. So we find, you know, a lot of participants will want to, you know, work through those process errors that might have occurred. And really, from our perspective, we focus on, in the tribunal, what is the decision that the person wants or needs for their supports or access, and what evidence do we need to get there. What we encourage where we do see process error or things that should happen that in our view shouldn't have happened is we encourage the complaint process to be used for that. Somebody brave might do a judicial review at some stage. Okay, so internal review, where you have a decision from the NDIA, you must do an internal review first. They're commonly called a Section 100 internal review. The agency, you must make your application within 3 months after receiving notice of the decision. So if it's about supports, it's the day you received your new plan. If it's about access, it's the day you received the access not met letter. Now, the time frame, I haven't put this in the slide, but the time frame for the agency to come back to you has actually, it's in the participant service guarantee, so it's not mandatory, but they do have to report against these things in their reporting. So has actually changed. I think it used to be 90 days that they had to come back to you with their decision on an internal review. It is now 60 days. Their current sort of achievement rate it can be commenced, and participants often do commence an internal review by ringing a person, and sometimes there's confusion as to whether an internal review has even been commenced. We all recommend that participants absolutely use the approved form when they're making their internal review request. We advise that all reports that have previously been given to the agency on a plan review or on the access be resubmitted with your internal review. And if you have information, so sometimes with an access not met letter, they'll specify why they think you haven't met the criteria. If you've got reports or evidence that specifically address that matter, try and pull that out in your internal review application. What I would the ones that go bad, I don't hear of at the moment very many internal reviews having a substantial change on the original decision, but then there are hundreds of thousands of decisions out there that we are not seeing, so other people might have a different experience. Now, once you do get the internal review decision is usually a 3 or 4 page letter. The reasoning in that can be a variable detail and transparency. I think that they are what they are, unfortunately. Once you get your internal review decision, that is when you can apply to the AAT, and you have 28 days to do so from the date you receive the internal review decision letter. Now, the application to the AAT is pretty straightforward. It's a free application. It's 3 pages. We generally, unless there is a particularly urgent reason why you need your decision dealt with really urgently, we just advise clients just to get it in, so that the tribunal can start, you know, putting your matter in the queue. Where there is a particular risk to a person, and we do see this particularly again on life transitions. The ones I've seen most recently are for older adults where a parent has passed away, and so there's been a significant change in their care. That emphasise that in a letter that goes to the tribunal, because the tribunal, as I understand, does have a triage system now when they get the applications, and where they see there is a particular risk to a participant, they will try and bring those matters forward. So I'll put the link there for the form. How am I going for time? Okay, 10 minutes. So in the AAT, I mean, for those of you who have been in the AAT with the Social Security or other government decision making, the tribunal has as its key objectives that it's accessible, fair, just, economical, informal and quick. Do encourage you, when you are in the AAT, to familiarise yourself with the general practice direction and also section 33 of the AAT Act. So that objective is an objective that we as the participant or the person appealing their decision has, but also the agency. So it's worth remembering that if you are seeing a delay. Now, once a person has made their application, a case number is assigned to them, and they will receive a bundle of documents called the T documents. These are sent by the agency to the applicant. They're usually 200 to 300 pages long because they include excerpts of the legislation and the operational rules, and they also include all the documents that the NDIA say is relevant to the decision. The weight on those documents, I mean, I think they used to arrive fairly promptly once you'd made your application, but we're seeing that there is a bigger and bigger delay coming from when a person makes their application to when they get the T documents. The tribunal will also set down a date for the first case conference, and the NDIA will contact an applicant and tell them that a lawyer has been assigned to their case. So that's a lawyer for the NDIA. What I've noticed recently is we're getting quite a few people contacting us quite panicked once they realise or once they're informed there will be a lawyer in the AAT for the NDIA. The NDIA is always represented. The applicants, I think there's some figures that the AAT have around who's represented from a participant perspective. We don't think they're particularly accurate, but at least 50% of people in the tribunal are self-represented or supported by a family member through the tribunal. There's another category of advocates, so supporting people, but we also note that a lot of support coordinators are falling by default really to be a person's advocate in the tribunal or support person, and I'll talk a little bit about that in a moment. Matters in the tribunal are not short. We commonly seeing them last between 6 to 12 months. Access decisions are particularly lengthy. We're seeing them last commonly for 2 years. A person can withdraw at any time. I think that's something always to remember. we don't see people withdrawing once they're there. They're usually there for the time. The process usually involves a series of case conferences, you know, where the issues are narrowed down to a point where an agreement is made between the parties, or there is a conciliation to try and resolve final issues, or there is ultimately a hearing conducted by the tribunal. And through those case conferences, there's a lot of activity, usually on the applicant, to gather further evidence. Our own experience at QAI is that most matters are resolved before going to hearing. We, since we've had this practice, have not actually gone to hearing. We've had lots get to, you know, very close, but invariably they resolve before the hearing. And I did note that in the quarterly report, of the 5,679 cases that have been in the AAT, only, and this is in December, only 145 had gone to a hearing. Just with the T documents, I don't think I said this earlier, it's really important to check them. If there's any document that your client has submitted in the last 12 months as a minimum to the tribunal, they should be in those T documents. If they're not, then email it to the tribunal and the NDIA lawyer. Before a first case conference, the NDIA will email what is usually entitled in the document heading the respondent statement of issues. These ideally would arrive, you know, a week or more before the case conference. That doesn't always happen. We often see them arriving the day before the case conference, or even sometimes the day of the case conference. But the statement of issues are really quite useful for us, because they set out what the NDIA say is in dispute in the decision, and then they say what they need to be satisfied that a criteria has been met. And so as a consequence, what we are now generally advising clients is, after an internal review decision, it might give you some indication as to why the support or the reason for your access has not been successful. But we actually don't encourage people to go and get additional evidence at that point, because at the statement of issues filed before the case conference, the agency will articulate, or should articulate, in much more detail what evidence and from whom they require. Just check the time. I'm running short here, sorry. Case conference and supporting documents. So really, with the case conferences, if you're with your client, have the T documents and the statement of issues ready for the case conference. If you know that your client is going to need, for example, an additional occupational therapist report, and that's clear on the statement of issues, and you can see from the evidence that they're missing some key evidence, we encourage people to, you know, have contacted an occupational therapist beforehand to line up so there's a reasonable time after the case conference in which that report can be given. If the NDIA are asking for further evidence and you're looking at the documents already filed and it looks really clear that it's there, we encourage participants and their advocates to absolutely raise that in the case conference and ask why and what is missing from that evidence, and don't be afraid to do that. Evidence gathering, I've just talked about that. With supports in dispute, this is one where sometimes we are taking a proactive approach before the first case conference. When we look at the internal review decision and we speak to the applicant, it's clear that what supports the NDIA thinks the applicant was looking for and what the applicant actually wants. And it's quite useful to really work these through and check the plan. Then I do encourage participants to email the tribunal and the NDIA lawyer at least 2 to 3 weeks before, being really clear about what it is the supports they are seeking are, and that way that can be incorporated into the statement of issues, and so that can save some time there if there is a lot of confusion as to what is being sought. The key documents that we absolutely encourage and find useful is a really comprehensive statement of lived experience for a person. Again, we might start preparing that before the case conference, but these days we wouldn't look to file it until after the first case conference. Reports from medical experts and allied health professionals, again, really important that they're meeting the criteria that is being asked to be satisfied. Reports can be funded where a person has a plan. Reports from therapists can be funded from a person's plan. If there's not enough funding in the plan, that should be raised at the case conference. On access, this is challenging, and what we are seeing, I'll talk about it briefly here, is that it may be suggested that an independent medical examination should occur or could occur. We take these IMEs on a case-by-case basis. Firstly, there's a recent case in the federal court that says the tribunal cannot compel a person to undertake an independent medical assessment. That was in the migration jurisdiction, but certainly that is our position, and that's what we say, and I'm not getting any indications that the NDIA or the tribunal don't agree with that. Where we know we can see there is evidence missing, or would be useful if we had additional medical evidence, this is the approach I take. I often will say, well, we'll need to see the questions that are being asked. Again, there has been pushback from the NDIA about this, but when it's an independent medical assessment, it's evidence being collected for the tribunal and not for the respondent. So I absolutely take the view that for our clients, we should fight for the best independent medical assessment that might occur. And if that means, being a bit, I don't know what the word is, but being strong about the conditions around those assessments, then absolutely. We've had some good experiences with them. Ultimately, especially in access, where people have been applying for access for a really long time and the medical evidence is missing, the independent medical assessments have made a real difference. So we don't discount them, but we're very cautious about how they would be used. So these are some of our common issues, and let me just check the time. I have run out of time. I do apologise. Just really quickly, with support coordinators, they do often fall into, by default really, supporting a participant at the tribunal. Where support coordination or any other support that the support coordinator may financially benefit from, they do have a conflict of interest, and they absolutely must declare that at the case conference, and there'll be some sort of discussion as to how to manage that. And the NDIA will not fund a support coordinator to attend a case conference. So if a support coordinator is intending to be there for a participant and there is nobody else, and all these other reasons, I say to them, well, you can't charge, and you need to make that really clear. It's unfortunate there is a significant, there are so many participants that that don't have support in the tribunal. So it is just a fact that that is happening. When you're at the tribunal, if a person is running out of funds, you must raise it up to the NDIA lawyer and or in the case conference. If the plan is running to the end of its life, then it should be remitted to the CEO via a Section 42D agreement. And what that does is it will produce a new plan, but that new plan remains the decision in the tribunal. We have found there's sometimes problems will occur if somebody applies outside of the tribunal for a Section 48 change of circumstances and a new plan gets issued completely separately from the tribunal. That plan is not the plan, that's the current plan, but it's not the one under the tribunal. So there can be lots of complications around that. When a proceeding is done and an agreement has been made, it's closed off by a 42C agreement. Independent, I've talked about, I'm not going to talk about Section 48 versus Section 100s. Just be careful if the agency is suggesting that to your client. I think we could do a whole session on Rule 5.1b of the support rules, which goes to funding that won't be supported because the agency says it's not related to your disability. If you are getting those, please have a look at this case of McLaughlin, which is the most recent case in the tribunal on this issue. Model litigant rules, we're encouraging people to, I've done it again. Sorry. Make complaints. Oh, look, there you go. It's telling me I can't do it anymore. So and finally, for those who work in this area a lot, you will have known about, heard about all the jurisdiction arguments. Just because somebody didn't ask for a support in their plan at the internal review does not mean they cannot ask for that support in the AAT, and that has now been settled through this case QDKH, so hopefully you shouldn't get any of those issues. QAI, we do a weekly advice service with clients, and we do have ongoing clients as well. These are just Queensland, but there are a number of other services funded to support participants through their NDIS appeals. Okay, apologies for going over, Carly.
No problem at all, Sian. Thank you so much. Obviously, there's a lot to get through, and there have been quite a few questions that have come through as well. So for those who need to head off, feel free to do so. We will answer all the questions, and you can return to this part of the recording if you need to. I can also see that some of the questions have been answered by Andrea, so I might sort of read some of those questions and answers out for the benefit of other people who might not have seen them. So firstly, a comment from Denise just at the beginning of the presentation, just to note that it has also put a lot of pressure on advocacy agencies who do not have funding for NDIS appeals and are trying to pick up the slack from those who are funded. So thank you for that comment. I'm sure that resonates.
Yeah, absolutely, Denise.
Yep.
Absolutely.
Yeah. So Susie has asked whether you could recommend any easy English fact sheets to give to clients that explain criteria such as meaning of permanence and the type of evidence that could help the NDI to make a decision. So Andrea, I might just read out what your response is to that, and Sian, you can feel free to add on to this as well. So she's just said, unfortunately, no, QAI is planning on revisiting its current fact sheets to be more user-friendly and include more detail and examples. Before doing so, they'll check in with colleagues nationwide and do desktop research to assess existing resources. Queensland Law Handbook, which is published by Caxton Legal Centre and available online, also has a chapter on the NDIS, which may be handy for practitioners. Sian, is there anything you wanted to add to that comment?
No, not really. I mean, we also are looking at trying to do little, what do you call, podcasts, or they're not podcasts, but little video clips. I think someone said in our office, TikTok friendly. So we are looking at doing that, so we can do sort of short 3 to 5 minute videos that sort of go, what's it like to be in the case conference, and that kind of thing, to sort of, so we are working on that. But yeah, it's a challenge for everybody and for us to get to that sort of work when the demand is so high.
Of course. So I might go to the next one, which is a question from Lyndall. So have you heard of any anecdotal evidence of people being refused the disability pension, then successfully getting it after turning 65 and reapplying? Is there a sense that the Commonwealth is delaying people going on disability so they can't get on the NDIS? Andrea has put some information into the chat about that one as well. So I'll read that out, and then Sian, you can add to it if you wish. The answer is no. The criteria for accessing the disability support pension and being granted access to the NDIS are different. QAI has many clients who believe that as they are pensioners, they also ought to be granted access to the NDIS, but this is incorrect. One is not dependent on the other, and vice versa. Did you want to add anything, Sian?
No, I mean, the disability support pension, absolutely, it's independent. Andrea's correct on that. I think the other part of the question is more, is there a sense that applications are being delayed or refused where people are close to the age of 65? I probably couldn't comment, but certainly we do see a lot of clients who are close to the age of 65.
So this question relates to the DSS as well. So, and no answer yet has been provided. So I'll just read this one out. It's a bit of a long one. So from Kelly, are you aware of any obligations on the DSS to provide support for participants to engage in appeals? At Community Legal Centres Australia, they're hearing that some legal aid commissions are not providing this support anymore as the funding isn't covering the cost of appeal support. So Kelly knows that there is some funding provided to legal assistance providers, but this doesn't seem to be sufficient, and she'd be interested in understanding if there are actually any obligations on the department. So I'm not sure whether you could comment on that, Sian.
I don't think I can comment on the department's obligations. They do fund. Obviously, we're funded by the by DSS, and all the legal aid commissions across the country are funded to support NDIS appeals. I think the issue is capacity. So we know in Queensland, I think legal aid has 2.5 lawyers. We at QAI, we funded to support disability advocates, but what we've done is Andrew and I have been incorporated into the team as principal solicitors to sort of add some depth. But other than legal aid, the funding is more directed at disability advocates, not at legal support. We're coming up to the end of the financial year and the funding rounds, so there just absolutely needs to be more funding for it, but I don't know off the top of my head what obligation DSS has.
Okay, great, thank you.
Otherwise, yeah, sorry.
No worries, thank you.
Good question though. We should look at it.
So this is another question that's come through from Denise. So should there be a minimum time frame for receipt of statement of issues before a case conference? They're looking at getting them through the day before or on the day, basically 5 minutes prior to the case conference, which means a further case conference has to be booked months into the future, delaying the matter. Any thoughts there?
Yeah, I think that would be really good. I did know when we were at a presentation from the AAT recently, and there seems to be an indication that they were going to look at some additional guidelines around NDIA matters, and how many case conferences there should be, and that sort of thing, and that would be be something that should be in there. I mean, obviously, as Denise has had the same experience that I've had, and I'm sure anyone else has had, where you get a 15, 25-page document half an hour before a case conference and no time to talk to your client about it. It's very distressing for the client. And yeah, it's a waste of time in the case conference because you haven't got proper instructions or even understood what they're asking. So I absolutely agree that would be a great outcome. We'll write that down.
So this question also from Denise has already been answered by Andrea, but again, I'll just read it out and read the response for the benefit of others. So are there any repercussions for the NDIA when not meeting timeframes as per participant service guarantee? And Andrea's noted that raising a failure to meet timeframes and guarantee via the feedback mechanism or making a complaint is warranted, but there are no repercussions in QAI's experience. A matter may just get more attention than it would otherwise. Any further thoughts there, Sian?
No, the only real driver for changing that sort of behaviour is the reporting that they have to do publicly against the participant service guarantee. So I've got it here in front of me, and it has the percentages of when they're meeting their target. Well, I should say it shouldn't be targets, but when they're meeting, and so that's the only ramification really. But yeah, we encourage complaints because the more complaints that are made, obviously, it's alerting the agency to the issue.
Carly and Sian, it's Andrea here. Just chiming in about that apparently it's better in terms of reporting that Sian's commenting on, that complaints are made to that feedback at NDIS email as opposed to a complaint to the CEO. So everything that's anything that goes to that feedback email is counted and reported against, whereas complaints to the CEO perhaps aren't.
Great, thank you.
So it's better to go via the feedback email if you can, or both.
Excellent. Just a couple more questions that have come through here. So from Golda, can a client ask for an extension of time if they cannot meet a limitation date? Would that be an internal or an external appeal?
So is that where they're making an application for an internal or external appeal? It's not where they've been asked to produce evidence in the tribunal. I think that's what the question is. Andrea, did you have some thoughts on this? I don't think you can ask for an extension on the dates within which you can make an appeal. Anecdotally, I've seen appeals at the external review phase being filed a couple of days late and them going through, but I wouldn't want to advise a client that or take the risk.
No, obviously, if you can, lodge your internal review within the 3-month time frame or your external appeal within the 28 days, it's best to do that. The AAT, I think, is pretty generous with granting extensions of time, and the typical considerations apply in terms of there being no prejudice to the other side, etc. Depends on how much time has passed. And likewise with internal review, I think if someone's beyond the 3 months, I have less experience of that, but if they were just a few days, I'd encourage a person to still lodge an internal review. There may be reasons why, so some people aren't advised of their review rights, and obviously that would be a good basis on which to say that they should be granted an extension within which to lodge their internal review. There's maybe a related question here. How often can you request an internal review before being forced to go to the AAT? Once you get your internal review decision, you go to the AAT. I think I get a sense that lots of people are nervous about going to the Administrative Appeals Tribunal, but it's set up to help people who are self-represented, and there's a very clear acknowledgement from AAT members and conference registrars that there aren't enough advocates and lawyers to go around to help people with these appeals. And going to the AAT seems to be what's required at the moment to get the outcomes you want. At internal review decisions are being affirmed more often than not in our experience. I don't know if you have more to add to that one, Sian.
No, all I would say is if someone is looking to do an internal review or an external review and they're worried because they haven't got the documents they think they need, just get it in anyway. And you can certainly at the internal review stage, you can let them know I've got more documents coming and file the documents, submit them, 2-3 weeks after you've made your application. Just get it started within the time.
Yeah, certainly. And when you're at the AAT, these matters take, 6 to 12 months to resolve. So lodge your application, reserve the review rights, then go about gathering your evidence afterwards.
I mean, that is something to make sure clients are aware of, that it's not a quick process. So once we're seeing, I think, it's 3 months before people get their first case conference after filing now, is my sense. So it's not a quick process.
Thank you. So another comment's just come through from Sarah, so regarding SOI. So the AAT general guideline says in 4.24, unless you are representing yourself, you and the decision maker must lodge with the AAT and give to each other a statement of issues at least 1 working day before the first conference. This is a brief statement setting out the specific issues that you think are in dispute in the application. So thanks for that, Sarah.
Thank you.
So I might, before we finish up, just a couple of questions that are sort of related around what QAI's role is in order to assist CLCs and others in this area, and what sort of templates QAI provides. So Andrea, I see that you've noted that QAI does provide discrete advice appointments prioritised for those most in need, which is a 1-hour telephone appointment and follow-up written advice, including provisions of templates, for example, statement of lived experience, request for report from medical professionals, etc. So if there's anything else you wanted to add to that for our audience, and I just see there's one more question that we might try and address if there's time as well.
Andrea, did you want to speak to that? Or?
Yeah, just quickly, I neglected to say we also help clients on an ongoing basis in addition to the discrete work, but obviously we, a handful of advocates can only assist, a few people each. So we have to really limit who we represent at the tribunal to those who really can't advocate for themselves or don't have any informal supports to advocate for them. And in terms of templates, we've spent a bit of time developing them, because we think if you can give someone a letter that they can give to their GP that's asking the right questions to elicit the information that we suspect the NDIA needs to move that person's case forward, that's going to make a difference. When we can't represent them and can't be there to hold their hand throughout the proceedings, we can at least steer them in the right direction by hopefully getting the right evidence.
Wonderful, thank you. And I might say this is the final question just from Rose. So thank you, Rose. Can an internal review from the agency and a tribunal review from the AAT for 2 different S100s but for the same person be made? Is it easy in the S100 being reviewed by the agency? If not appropriate, be added to the AAT review?
Andrea, did you want to talk to that, or do you want me to?
All I would say is that you can add proceedings. There's sometimes very messy steps that are taken by the NDIA in a lead up to someone lodging an external appeal in the AAT, and then jurisdictional issues arise, and there's no option other than for the applicant to lodge a further internal review to enliven the tribunal's jurisdiction, and then that internal review is joined with an internal review that was already, being processed. I don't know if that's what the question is about, but certainly you can join matters together within the AAT. I don't know if you had more to add, Sian.
Yeah, no, only that we've certainly got that situation, particularly arising from before the jurisdictional issue came up, and where that situation happens where someone's done a section 48 outside of the tribunal proceedings and there's a new plan, it does sort of need to be brought into the tribunal, so that yes, it does happen, and you need to talk to the registrar about that, the case manager, to try and bring them together.
It may work, it may not. It just depends on the steps that have, you know, preceded that application in the tribunal and whether the tribunal has jurisdiction or not. We have a large number of advices that we do where a person has lodged an internal review and then they've been told by the NDIA or someone else, oh no, you should lodge a section 48 to change your circumstances review now, and a new plan's issued. So then they no longer they can't take it to the AT, they have to go back to square one and lodge another internal review, and it's very frustrating. And, you know, we're talking, you know, 12 plus months of attempts to have a decision reviewed, and unfortunately, because the necessary steps before the AAT proceedings have been lodged haven't been taken, they can't pursue the matter further.
All right, great. I might wrap up the session there, and thank you to everyone for all those excellent questions. So on behalf of everyone who joined into today's session, thank you so much, Sian, for presenting such an informative presentation, and to Andrea as well for assisting with the question answering at the end. As I mentioned, this webinar has been recorded, so we'll get that recording out to everyone probably this afternoon, so you can have a look at it and share with your colleagues if you need to. Before I do close up the presentation, just a reminder to complete the feedback survey that will pop up automatically on the screen when the webinar finishes. That feedback is really helpful to CLCQ and to our presenters to continue to bring you good and relevant webinar content. So for now, though, I'll thank you to our presenters again, and thank you also to our audience for joining us today. We look forward to seeing you at the next CLCQ webinar. Take care, everyone, and see you later. Thank you.